Navigating Customs Penalties, ISF Fines Negotiation. Welcome to our video on negotiating customs penalties for importer security filing, ISF, fines. Customs penalties can be imposed when importers fail to comply with ISF regulations, resulting in financial burdens and potential delays in the customs clearance process. In this video, we will provide you with insights and strategies for negotiating customs penalties related to ISF fines. Understanding customs penalties for ISF fines. Customs penalties are imposed by U.S. Customs and Border Protection, CBP, when an importer fails to comply with ISF regulations or submit their ISF on time. These penalties can vary depending on the severity of the non-compliance and may include monetary fines and other enforcement actions. Early identification and assessment. Upon receiving a penalty notice, importers should promptly identify and assess the specifics of the penalty. This includes understanding the reason for the penalty, the amount involved, the time frame for response, and any associated documentation or evidence required for the negotiation process. Reviewing the penalty notice. Importers should thoroughly review the penalty notice to ensure accuracy. Carefully examine the basis of the penalty, any supporting evidence provided by CBP, and any discrepancies that could impact negotiations. Understanding the details of the penalty notice is crucial for formulating an effective negotiation strategy. Seeking legal counsel. Engaging the services of a customs attorney or legal counsel experienced in customs compliance can greatly assist in negotiating customs penalties. These professionals possess specialized knowledge of customs laws and regulations, providing valuable insights and guidance throughout the negotiation process. Gathering evidence. Importers should gather relevant evidence to support their position during penalty negotiations. This may include documentation related to the ISF filing process, communications with customs brokers, and any extenuating circumstances that may have contributed to the non-compliance. Robust evidence can strengthen the importer's case and potential negotiation outcomes. Developing a negotiation strategy. Importers should formulate a negotiation strategy based on a careful analysis of the penalty notice and the evidence gathered. This strategy should include identifying points of contention, determining potential mitigating factors, and establishing a clear and compelling argument to present during negotiations. Communication with CBP. Importers should engage in open and constructive communication with the CBP contact provided in the penalty notice. Timely and professional correspondence is key to establishing a cooperative environment and seeking clarification on any discrepancies or questions. Maintaining clear lines of communication is crucial throughout the negotiation process. Presenting a strong case. During negotiations, importers should present a strong case highlighting any mitigating factors or extenuating circumstances surrounding the ISF non-compliance. This may include demonstrating a history of compliance, addressing procedural issues, or providing evidence of proactive efforts to rectify any mistakes or improve the compliance process. Demonstrating remedial measures. Importers should demonstrate their commitment to compliance and ongoing improvement by implementing remedial measures. This can include strengthened internal processes, additional training for staff involved in the ISF filing, and enhanced communication protocols with customs brokers to prevent future non-compliance. Understanding penalty mitigation factors. Importers should familiarize themselves with penalty mitigation factors outlined by CBP. These factors, such as the importer's compliance history, good faith efforts to comply, self-disclosure of errors, and cooperation during the investigation, can potentially reduce or mitigate penalties during negotiations. Requesting administrative review. In cases where penalty negotiations do not yield a satisfactory resolution, importers may have the option to request an administrative review. This process allows for an independent review of the penalty decision, providing an additional opportunity to present evidence and arguments for further consideration. Considering penalty reduction programs. Importers should explore available penalty reduction programs offered by CBP. These programs, such as the First-Time Importer Program and the Reconciliation Program, may offer opportunities for penalty reduction or amnesty under certain conditions. Understanding the requirements and criteria for each program is important when negotiating penalties. Evaluating settlement options. Importers should carefully evaluate settlement options presented during the negotiation process. This may include considering a settlement offer from CBP that involves reduced penalties in exchange for specific actions or commitments from the importer. Evaluating these options in the context of the specific case and its potential long-term implications is crucial for informed decision-making. Analyzing the cost-benefit ratio. Importers should weigh the cost-benefit ratio of continuing negotiations versus accepting a potential settlement offer. Consider the potential financial impact of prolonged negotiations, including legal costs and potential disruptions to business operations. Balancing the potential savings from penalty reduction against the associated costs is important when evaluating negotiation outcomes. Maintaining professionalism and cooperation. Throughout the negotiation process, importers should maintain a professional and cooperative approach. Exhibiting a willingness to cooperate, addressing CBP's concerns, and offering proactive solutions can positively influence the negotiations and potentially lead to more favorable outcomes. Compliance going forward. Demonstrating a commitment to future compliance is crucial during penalty negotiations. Importers should highlight their efforts to strengthen internal processes, establish a culture of compliance, and implement measures to prevent similar non-compliance incidents in the future. Showing a proactive approach toward compliance can enhance negotiation outcomes. Ensuring timely follow-up. Importers should adhere to any deadlines or timelines set during the negotiation process. Promptly responding to requests for information, providing requested documentation, and adhering to established communication channels demonstrate professionalism and cooperation, fostering a positive environment for resolving the penalty issue. Considering appeals options. If negotiations do not result in a satisfactory resolution, importers may consider appealing the penalty decision. This involves filing an appeal with CBP's Fines, Penalties, and Forfeitures (FP&F) office or seeking further legal advice. Appealing a penalty decision is a complex process, and experienced legal counsel can guide importers through the necessary steps. Continuous improvement. Importers should embrace a culture of continuous improvement to prevent future instances of non-compliance. This includes reviewing and enhancing internal processes, conducting regular compliance audits, providing ongoing training to staff, and staying informed about changes to customs regulations that may impact future compliance. Thank you for watching our video on negotiating customs penalties for importer security filing, ISF, fines. By understanding the penalty notice, gathering evidence, developing a negotiation strategy, and maintaining open communication, importers can effectively negotiate customs penalties related to ISF fines. Remember, seeking legal counsel and cooperation with customs authorities are important steps in achieving favorable negotiation outcomes.